Because of my association with Guantanamo that Mike alluded to yesterday, when I spoke, I lobbied hard for the opportunity to introduce General John Baker to you. And let me digress for just a second. The system that Josh Draytel just discussed is the good system. That's the one those of us who've been litigating in Guantanamo want to get to, which should tell you something about how weird Guantanamo is. I want to take you back to October of last year. I had been representing Abdul Rahim al-Nashri, who was charged in the bombing of the USS Cole, for approximately 10 years. As a result of some discoveries of what I'm allowed to say are listening devices or microphones, we concluded, myself and two other civilian lawyers who were part of the team, concluded after seeking advice from an ethicist, Ellen Yarosowski, that we were obligated to withdraw. We took this information to General Baker, who is the Chief Defense Counsel for the Military Commission's Defense Organization, and after he did his due diligence, he agreed that we had shown good cause and could withdraw. The judge, however, concluded that it wasn't General Baker's decision, it was the judge, and we were ordered to go, myself and the others were ordered to go to Guantanamo to continue representing our client. General Baker said, essentially, the decision whether to comply with this order is up to you, and we concluded that since Americans can't be forced to go to Guantanamo and since our representation would be unethical, we wouldn't go. He, however, had to go. And knowing that it was going to be an absolute shitstorm when he got there, and it was. I was following it on Twitter, and I will tell you that watching somebody be held, well, what happened was he was ordered to rescind the order allowing us to withdraw. And I think the judge's exact words were, get them on a plane and get them down here. In an act of almost unimaginable courage in my book, his exact response was, no, sir, I'm not going to do that. And the judge said, okay, that's fine. Come back tomorrow and we'll have your contempt hearing, which lasted maybe 15 minutes. He wasn't allowed to say anything. His lawyer wasn't allowed to say anything. And then he was ordered confined to essentially a FEMA trailer for 21 days and fined $1,000. At, I will tell you, extraordinary risk to his career. And I have to tell you, watching somebody take a bullet for me, was breathtaking in his courage. Through the NACDL strike force, I'm happy to say that his sentence was set aside very quickly as a result of a habeas petition Barry Pollock filed. His conviction was set aside in June of this year, and he remains the Chief Defense Counsel at the military commissions. The highest praise I can give General Baker is that he is not a Marine who happens to be a lawyer. Those things are true. John Baker is the criminal defense lawyer we all aspire to be. Brave, courageous, dedicated to the Constitution, who happens to be a Marine. He is at the absolute tip of the spear in the fight to defend the Constitution. And I'm honored to introduce him to you. He is a great lawyer and an undiscovered American hero. Thank you.
Well, with that introduction, I think I should just leave. It really is a pleasure to be here, particularly given the support that this organization has given to the Military Commissions Defense Organization and its mission of defending the rule of law at Guantanamo Bay. I think it's particularly fitting that my talk follow Joshua Dratel's because he, Nancy Hollander, and so many others from NACDL partnered with the ACLU in 2008 to form the John Adams Project, to provide Guantanamo detainees with access to a deep bench of some of the greatest criminal defense lawyers in the country. Josh was also one of David Hicks's counsel and did an amazing job in that case. So it's important that I start this off by saying thank you and how grateful we are for the unwavering support that NACDL has provided to the Military Commissions Defense Organization. I also want to say a personal thank you to Norman Reamer and Jumana Musa and the NACDL Task Force for connecting me with Barry Pollock and Addie Schmidt when I found myself facing confinement at Gitmo. And Barry and Addie, thank you and the rest of the team for your counsel, your time, and your dedication to the rule of law, and to my case in particular. Before I go any further, particularly after that introduction, let me confess to being more than a little bit nervous. Lately, I've been talking to law students who are a pretty easy group to impress. One of the messages I try to convey to law students who are eager to make a difference and to change the world is that lawyering, particularly defense lawyering, matters. I explain to them that ours is a tough, demanding, and often frustrating profession. But what we do makes a difference. That the right to counsel is a bedrock principle of this nation, and that people like each of you are our generation's John Adams. To make this point, I sometimes read a quote from Clarence Darrow. Quote, "To be an effective criminal defense attorney, an attorney must be prepared to be demanding, outrageous, irreverent, blasphemous, a rogue, a renegade, and a hated, isolated, and lonely person. For few love a spokesman for the despised and for the damned." But I also tell these students that Clarence Darrow missed a descriptor, because a criminal defense attorney is also a patriot. Each of us plays a crucial role in trying to keep the Constitution, the Bill of Rights, and justice alive in courtrooms across the country. But today I'm not talking to law students, I'm talking to their and to my heroes. So please forgive my nervousness. They and I are in awe of you and what you do every day in courtrooms across this country. To introduce you to the Alice in Wonderland, through the looking glass world of Guantanamo Bay, I'm going to use remarks that have been vetted by a security professional. My apologies for reading from a prepared speech, but it is important that I do not stray into a discussion of potentially classified information. Some of you may be familiar with a recent opinion of the D.C. District Court which said overturned my conviction for contempt. I wish I were able to discuss that decision with you at length, but it isn't final yet, and on the advice of some pretty good counsel, I will talk about something else. So I'm going to give you a talk on the theme of this year's conference, murder, mayhem, and malice. Because when it comes to mayhem and malice, Guantanamo litigation has them in spades. My goal today is to present to you the military commissions as a case study on why defense lawyers matter and how important it is to a just society that defense lawyers continue to persevere, no matter how crazy the environment you are litigating in. I also want to give you, the patriots on the front lines fighting government overreach and defending the rule of law in courtrooms across the country, a sense of some of the things the government is trying out in what used to be called America's Battle Lab, Guantanamo Bay. To be clear, these views that I am about to express are mine and mine alone. They do not reflect the views of the Department of Defense, the United States government, or any agency or instrumentality thereof. As you can see, I'm a career Marine. After starting out as a logistician, the Marine Corps sent me to law school, and my legal career has primarily been in the military justice system, with pretty significant experience in 3 important seats in any courtroom. I've been a defense counsel, I've been a prosecutor, and I've been a judge. Before my current assignment, I could not conceive of some of the extraordinary things that are so perilous to a fair trial that I've seen unfold in the military commissions down at Guantanamo. For 3 years now, I've been privileged to head the Military Commissions Defense Organization, or the MCDO as we call it. I am extremely proud to lead this group and to recognize the phenomenal work done by the advocates assigned to it. In today's challenging world, the MCDO will continue to be the voice for justice at Guantanamo Bay, and we will continue to fight for the just application of law in a military commissions system that is flawed in both design and in execution. The attorneys, paralegals, investigators, security officers, case analysts, interpreters, information technology experts, and operations and administrative support personnel at the MCDO do this important work because most of them have taken an oath to, quote, support and defend the Constitution of the United States against all enemies, foreign and domestic. Like them, you also swore an oath when becoming a member of your own bars. Perhaps my favorite bar oath comes from Indiana, which reads, quote, I will never reject from any consideration personal to myself the cause of the defenseless. It is with that attitude that we at the MCDO, like all of you, approach every day. As the Chief Defense Counsel, I do not represent any accused, and I do not make litigation decisions. Instead, I supervise the defense teams that represent their individual clients. I see myself primarily as their protector and their advocate. I watch them in court, I fight to get them resources, I listen when they are frustrated or want to talk about their cases, and I encourage them to continue their tireless and too often thankless work defending their clients by reminding them how important what they do is. One of the advantages of my position is that I get to see all the teams and all the cases, which gives me a different perspective than the individual team members who are rightly focused on their cases and their clients. And what I see is a system that can't manage to bring some of the highest profile criminal defendants in American history to a fair trial. I also see a group of defense attorneys whose efforts to work within this system provide an example to all of us about what it means to be a successful advocate. It is their work that has exposed the Guantanamo Bay military commissions as a failed experiment. I'm frequently asked why these trials are taking so long. For many, delay is the biggest concern. Delay is a huge problem. October marks the 18th anniversary of the USS Cole bombing, and September marks the 17th anniversary of the 9/11 attacks. We have no trial set for this year, and the judge in the 9/11 case announced recently that the 9/11 trial will not start next year either. This delay is the byproduct of problems that are more fundamental, with the potential to reach far beyond these cases, both as precedent and by corrupting our core principles. The issues in our cases, particularly the effects of torture, would cripple any normal court case. And they are layered on top of the mayhem embedded in this failed experiment that we call the Guantanamo military commissions. To illustrate what I mean, I'm going to discuss some of the major issues currently facing the MCDO defense teams. These issues demonstrate at varying levels why the Guantanamo military commissions are a national disgrace. And, not coincidentally, these same evidence shine a light on why lawyering matters and what it truly means to be a criminal defense attorney. First, the military commissions operate on a level of secrecy that has to be seen to be believed. The government seems to regularly use classification to conceal information that it finds embarrassing. It also regularly refuses to produce relevant documents claiming a, quote, national security privilege, although they can't explain how information published in newspapers or in foreign courts is being protected by hiding it from defense attorneys with security clearances. Just this week, during a hearing in the 9/11 case that I attended at Gitmo, the military judge asked one defense counsel how he had gotten a piece of information that the government had previously withheld, claiming this information was so important to national security that it could not be provided to a defense team in a capital case. The defense counsel explained that the government had provided the same information to BuzzFeed in a FOIA response. When the clearly frustrated judge asked the prosecutor to explain what could possibly justify hiding facts from a defense team in a capital case, but then providing those same facts to a reporter a year later, the prosecutor tap danced around the question. Just like they did the year before, when Team Albalucci caught the CIA providing details concerning their client's torture to the maker of the film Zero Dark 30, the same information that the government had refused to provide to his defense team. The government's demand for secrecy, particularly about the details and effects of torture, also creates unimaginable roadblocks for defense investigations. For example, in January, in stark reversal of the government's position stated on the record in 2013, the chief prosecutor explicitly threatened the defense counsel with the possibility of criminal prosecution if they continued to conduct independent investigations of their client's torture overseas. Let me repeat that. The chief prosecutor explicitly threatened the defense counsel with the possibility of criminal prosecution if they continued to conduct independent investigations of their client's torture overseas. Defense attempts to speak to witnesses stateside led to the same threat of prosecution. When the defense protested and said to the judge, "Hey, these are capital cases. We need to do an investigation," the prosecution told the judge that the defense had no right to, quote, investigate. Later, the prosecution offered a compromise where counsel would not face prosecution, provided they allowed an intelligence agency to pre-approve their proposed questions to witnesses about torture. Not surprisingly, the defense teams have found this, quote, compromise unworkable, and defense investigations remain on hold, awaiting judicial intervention. Keep in mind that according to the Senate torture report, the events the defense are trying to investigate happened a decade and a half ago, and that the defense counsel had the same security clearances as the prosecutors. But despite these clearances, despite these being capital cases, and despite the fact that they are seeking to what they are seeking to investigate is their own client's time in pretrial custody, somebody has determined that these defense counsel do not, quote, need to know the information. As everyone who's ever litigated a Brady motion knows, the desire to keep information from the defense is not limited to the national security arena. To fight for this sort of information, a defense attorney must be flexible, exercise good judgment, and possess a profound amount of patience. She must be tenacious, because her duty is to investigate and to develop her client's case, even if the government threatens her for doing so. And no matter where she goes to work each day, whether it be at Camp Justice at Guantanamo Bay or a state court in Texas, she must also be a true patriot. Oftentimes, that means taking positions that run contrary to the politics of the day, and in the highly adversarial atmosphere of Guantanamo, it always seems to make taking a position the government will not agree with. But our clients' lives depend on doing so, and at the end of the day, so does our commitment as a nation to maintaining a government of law. To understand the government's zeal for secrecy, you must understand what the government is trying to hide. Each time information about CIA torture becomes public, people recoil and say that must be the worst that happened. Yet, another revelation emerges that manages to outstrip the horror of the previous one. You probably have had clients who have suffered terrible abuse, but rarely has that been done by the very people who are still detaining them, who are pursuing their prosecution, and who are seeking to execute them. You probably believe that you know about the events in the CIA program, given their coverage in the press. But did you know that the CIA regularly threatened detainees' families, including threats to kill children? While you probably know that Khalid Sheikh Mohammed was subjected to waterboarding, did you know that he and others were subjected to a form of anal rape, euphemistically called rectal rehydration? While you probably know that detainees were deprived of sleep for days at a time, forced to stand with arms shackled overhead, naked in cold rooms, with blinding lights and deafening sounds, did you know that some were forced to urinate and defecate on themselves? And that the CIA had a policy allowing them to be left in their own filth until, quote, evidence of loss of skin integrity due to contact with human waste materials, unquote, or to be more precise, until they developed open sores. While you've probably heard the claims that our government only used torture for intelligence purposes, did you know that earlier this month, the government finally declassified their objective for torturing Ammar al-Baluchi? They tortured Ammar as a form of human experimentation, using him as a test subject to train new interrogators. While you probably know that Abu Zubaydah was interrogated while severely wounded, did you know that he was repeatedly waterboarded, slammed against a wall, forced to stand, sit, or crouch inside wooden boxes with such violence that his bandages, quote, came completely off? And did you know that 3 days later, the guards, quote, swapped out subjects' wrist shackles for a clean pair, since they occasionally come into contact with the exposed wound? While you probably know that Majid Khan, a lawful U.S. resident, grew up in Baltimore, did you know that when Mr. Khan refused to eat, detention personnel inserted a tube into his rectum, pumped it with 2 bottles of Ensure, and a, quote, lunch tray, which consisted of pureed hummus, pasta with sauce, nuts, and raisins? According to CIA records, he was, quote, very hostile to rectal feeding and removed the rectal tube as soon as he was allowed to. Let me point out that this describes a man forced to participate in his own torture. On 2 occasions, Majid Khan attempted to cut his wrists. He tried to chew his arm at the inner elbow, tried to cut a vein at the top of his foot, and to cut into the skin at the elbow joint using a filed toothbrush. Other detainees also attempted to end their lives, or asked to be killed, or to be allowed to die. Even with these details, you do not know the worst that happened. The worst is still hidden. The defense counsel know more than the public, but they don't know the worst either. They should, and so should the juries, especially in capital trials. As a MCDO defense counsel argued when challenging the government's torture-hiding discovery practices, he, quote, needs to know the gritty, granular details of what U.S. agents did to his client. His jury needs to smell the urine, the feces, the blood, the sweat, and see just how vile and disgusting this process was. Then, if convicted, defense lawyers can ask the jury, do you kill him now? This torture, and let's call it that, this torture was not perpetrated by rogue elements. These monstrous acts were systemically instituted, embraced, and promoted at the highest level of the United States government. This same government is fighting tooth and nail to hide information about these cases at a terrible cost to all of us. Once you understand what the government is hiding, the imperative for the rule of law is elevated tenfold, and the commission systems becomes more than wrong, it is repulsive. And the government wants to hide this too. Beyond their efforts to hide the gritty, granular details of the torture done to our clients, the government continuously demonstrates that it has no respect for the responsibility of defense attorneys, much less capital defenders. I have lost count of the number of times that the government has pushed a judge to set a trial date, or represented to a defense team or a judge that it is, quote, ready for trial, or that the government's discovery obligations are complete. Of course, these statements have always been followed by some new incident that makes more discovery necessary, pushing the trial date further and further away. Nor does the government respect the basic demands of capital defense. In court recently, one prosecutor waved away the entire concept of mitigation, saying that there was no need for the defense to interview or to present testimony from people who had tortured their clients, because the government would simply stipulate the sanitized descriptions of what they claimed had occurred. But when the judge pressed him to put his money where his mouth was, since the government has never actually offered any such proposed stipulation, the prosecutor said, quote, we have in essence done what you proposed. We've given them discovery. It should come at no surprise that the prohibitions on the defense investigations of torture, in addition to being about secrecy, are also based in this lack of respect for the defense function. In fact, recently the government insinuated that continuing to investigate torture was a waste of time, was cumulative, or my own personal favorite, not relevant to the actual facts at issue. This is because, according to the government, CIA torturers, mitigation witnesses, if there ever were any, are irrelevant, since, quote, they are not witnesses for the government. What this all boils down to is that MCDO attorneys spend a debilitating amount of time litigating to be allowed to perform the very basics of their duties as defense attorneys. Like you all, they fight every day to meet their ethical obligations. Obligations not just to our clients, but to due process. And like you, they act as a clarion call to resist letting the American criminal justice system become one in which the government pretends not to know that a man facing death is entitled to argue for his own life. They, like you, are the voices that call for a return to the American justice system as it was intended to be. Finally, and I plan to spend some time on this, throughout the past year and a half, my defense teams and I have been dealing with the aftermath of the government's continued disregard for the sanctity of the attorney-client relationship. In fact, that's not just an issue that we've been dealing with this year. This is an umbrella issue that has plagued the military commission system almost since the time the clients were first charged. The government's disregard for the sanctity of the attorney-client relationship denies military commissions defendants the right to counsel, and it sets a dangerous precedent for the American criminal justice system. As you know, the right to effective assistance of counsel includes the right of private consultation with counsel. The purpose of the attorney-client privilege, the Supreme Court has said, is to, quote, encourage full and frank communication between attorneys and their clients, and thereby promote broader public interest in the observance of law and administration of justice. For any criminal justice system to work, defendants must have the ability to trust their lawyers and to speak with them in confidence. If you don't have that, you don't have a legitimate legal system. The stark and very depressing reality is, down at Guantanamo Bay, the defendants have no reason to trust their lawyers or to think that they can speak with them in confidence. MCDO lawyers have told their clients no one will read their privileged materials, that no member of their defense team will be enlisted by the government to violate the attorney-client privilege, and that no one will, quote, unintentionally overhear their privileged communications with their attorneys. Yet, despite their best efforts, over and over again, when MCDO lawyers tell their clients they can speak frankly, another government intrusion is revealed, and the defense counsel look at best like fools and at worst like liars. Let's go back to 2011, when the cases in this latest iteration of the failed experiment began. Joint Task Force Guantanamo, which is the command responsible for the custody of the detainees down at Gitmo, seized, copied, and translated all written material in the detainees' possession. This included documents very clearly marked as attorney-client privileged. And incredibly, the seizure of this privileged material was done after consultation with the Joint Task Force lawyers. The military judge who addressed this search and seizure concluded that it, quote, infringed on the attorney-client privilege, and the government promised not to engage in conduct that infringed on the attorney-client privilege. Yet similar conduct has continued. Next, in the space of 3 months beginning in January 2013, the 9/11 defense teams discovered that an intelligence agency could shut down the live courtroom proceedings without the knowledge or assent of the judge, and that the same agency had the ability to listen to courtroom conversations, including between defense counsel and their clients through the microphones placed on defense tables. Next, in February 2013, a MCDO attorney took it upon himself to climb onto a chair in an attorney-client meeting room and write down the make and model of what the Joint Task Force guards and one Joint Task Force lawyer had explained to be a smoke detector mounted on the ceiling. With the make and model, the MCDO lawyer returned to his office to Google the company and discovered that the company didn't make smoke detectors, but instead made microphones that looked like smoke detectors. These hidden listening devices existed in all attorney-client meeting rooms where the commission's defendants met with defense counsel. When the issue was litigated, The government promised not to utilize such devices to infringe on the attorney-client privilege. As time has passed, we would learn this is yet another broken promise. Then, on a Sunday in 2014, shortly after he had come home from church, two members of the FBI appeared at the home of a MCDO staff member. After some conversation, what interrogators sometimes call rapport building, the FBI agents asked the MCDO staff member to reveal privileged information about the case he was working on, as well as other pending military commissions cases. The FBI agents were successful in persuading the MCDO staff member to sign a contract to become a confidential informant against the MCDO, and he provided the government with a treasure trove of privileged materials. We have not even begun to appreciate the fallout of that broken promise, as the litigation surrounding this issue is far from over. Then, in February 2015, one of the 9/11 accused announced that he recognized the court interpreter sitting at his defense table from one of the black sites where he was interrogated and tortured. This shocking revelation that a government-provided defense interpreter may have been involved in the torture program led to well over a year's delay in the proceedings, while hearings were canceled and court-ordered investigations were conducted. And like the FBI informant issue, litigation on this black site interpreter issue is far from over. I'm going to skip over many other incidents and fast forward to May of 2017, when prosecutors in two cases filed classified notices informing the presiding judges and the defense teams in these cases of certain events. As a result of those filings, I recommended to all MCDO defense counsel that they discontinue attorney-client meetings with their clients until they could, quote, know with certainty that improper monitoring of such meetings is not occurring. In the wacky world of Guantanamo, this essentially means no attorney-client communications at all, other than short, heavily screened letters, because my defense counsel are not permitted telephone communication with their clients at Guantanamo Bay. It's hard to overstate how serious of an issue this is. I, the supervisory attorney with the regulatory responsibility to advise all military commissions defense counsel on the ethical practice of law, had to recommend that defense counsel not meet with their clients. Shortly after my recommendation to the defense counsel, the government admitted that some attorney-client communications had been, as they described it, quote, unintentionally overheard at Gitmo. But they claimed that none of the active cases were impacted. All of this put counsel in a tremendously difficult situation. Do they meet with their clients in a situation where their supervisor has recommended that they not do so? Where there could be secret monitoring of their conversations with their client? Not meeting might be the only ethical option from the defense counsel's perspective. But in order to stop meeting with a capital client, counsel would have to give him some kind of explanation. But the defendants at Guantanamo Bay don't have security clearances, so they can't be told classified information, even about their own case, their own rights, and their own defense. This made some of the defense attorneys fearful of meeting with their clients, lest their conversations be overheard. But they couldn't tell their clients about that fear, since they would risk getting prosecuted for leaking classified information. What I can tell you now is that this past March, the government finally admitted publicly that there were hidden microphones in the location where at least Mr. al-Nashiri, the accused in the USS Cole case, met with his lawyers. The government attempted to minimize these microphones by calling them, quote, legacy microphones. The al-Nashiri defense team discovered one of them in August of last year, but they were told the existence of the hidden microphone was classified. They asked for discovery about the microphone, but that was denied. They asked for a hearing about the issue, but that too was denied because the prosecution promised, I think it was a pinky swear, that they, the members of the prosecution, had not personally listened in on all or any of al-Nashiri's attorney-client meetings. And remember, attorneys can't tell Guantanamo defendants about classified information, but the members of the al-Nashiri defense team tried. They asked the judge for special permission to simply inform their clients about the risks they had discovered, but that too was denied. That meant they couldn't tell Mr. al-Nashiri that someone had potentially bugged the rooms where he'd been meeting with his lawyers. After this, Three of Mr. El-Nashiri's lawyers requested my permission to withdraw from that case due to the ethical situation in which they found themselves. As Rick discussed, Rick was one of those three lawyers. Rick is Mr. El-Nashiri's learned counsel, counsel required by law to be an expert in death penalty defense. After some significant deliberation, I'd found that each had provided good cause to be excused, and I granted that permission to withdraw. It may seem strange from a civilian perspective, but the governing rules in the commission system issued by the Secretary of Defense give me, the Chief Defense Counsel, that responsibility. This, however, provoked the military judge, the same one that had denied them discovery, the same one that had denied them a hearing, the same one that had denied their request to simply inform Mr. El-Nashiri about what they had found. He ordered me to rescind that refusal, and I declined that order as unlawful. He held me in contempt and gave me a 21-day sentence of confinement. I challenged that conviction, and with the help of Barry Pollock, Addie Schmidt, and their NACDL task force team members, a federal judge recently ruled the military judge acted unlawfully and beyond his authority and overturned that conviction. But in the meantime, down at Guantanamo, that same military judge went ahead with hearings in the case during 3 different months. Hearings in which the government introduced evidence into the record, despite no jury having been selected yet, all while Mr. El-Nashiri did not have a lawyer with him who'd ever tried a murder case, much less a death penalty case. The kicker to all of this is that the El-Nashiri team only found 1 microphone. But the government's later statement about the matter admitted that there was more than 1 microphone removed from that meeting location. How all of this gets resolved, I honestly don't know. But what I do know is that what happens down at Guantanamo Bay matters. After the passage of the Military Commissions Act, a former chief prosecutor for the military commissions stated that his goal for the Guantanamo military commissions was to be remembered in the same favorable light as the Nuremberg trials. The U.S. government has unfortunately failed and continues to fail this test. Future generations will look back at these proceedings as a missed opportunity for America to show the world its commitment to justice, its commitment to human rights, and its commitment to the rule of law. If the United States government still intends to use Nuremberg as its guide, they would be wise to listen to the chief prosecutor at Nuremberg, Justice Robert Jackson, who recognized the danger of powerful nations unilaterally dispensing justice onto a purported enemy. Justice Jackson said in his opening argument at Nuremberg, "We must never forget that the record on which we judge these defendants today is a record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. Instead of respecting the Constitution and ensuring equal protection under the law, the United States government is choosing to drink from a poisoned chalice at Guantanamo Bay." Thank you very much.